Hello, and thank you for joining today's estate planning webinar. My name is Melissa Valancourt, and I'm a chartered advisor in philanthropy. The CAP designation is a certificate of advanced study that provides specialized training designed to help donors determine which non-cash assets make the most tax-smart charitable gifts. And I'm currently putting my credentials to work as Director of Development at the Syracuse University College of Law. Like a lot of directors in development in roles like mine, I travel all over the country, meeting law alumni and exploring ways for them to connect with and support the law school. It was on one of these trips a few months ago that I met today's presenter, and we had such an enjoyable conversation. I thought fellow alumni would be interested in hearing about his experiences. So it's with great pleasure that I introduce Tim Crowley. Tim is a Syracuse Law class of 1997 and has spent nearly 30 years as a trusts and estates attorney. Today's presentation is an overview of his answer to a frequent request from his clients to recommend resources on estate planning that aren't boring or technical. Through anecdotes from his own practice, Tim will take us through 7 categories that everyone considering crafting or revising an estate plan should consider. Tim will speak for about 45 minutes, and we've reserved a block of time for Q&A at the conclusion of his presentation. At that time, you're welcome to type your questions in the chat or raise your hand, turn on your mic and camera and ask away. With that, I'll turn it over to Tim with the caveat that I believe if my video isn't working, my screen share won't work either. So I'm going
Your screen share
to
should
try.
still work, Melissa, if you want to give it a try.
Go ahead and give it a try. Okay.
Well, thank you to Melissa and Adrian and the College of Law. I'm pleased to be able to present to you about, there it is, about estate planning. As Melissa mentioned, I graduated in 97, so I've been out about 30 years. I came in as a non-traditional student. I was a little bit older. I was in my mid-30s. Over my nearly 30-year legal career as a trust and estates attorney, clients often ask, they would say, isn't there a resource out there that can help me understand estate planning? And many of the resources that I looked at were very technical. And so I decided, as I'm nearing retirement, to write my own. I wrote my own book called The Last Word: 7 Estate Planning Considerations to help people understand and in a less technical way and with what are hopefully amusing anecdotes. For those of you who are ethically attuned, you may hear these stories and you say, are you breaching any ethics? Well, I actually had the retired state chief disciplinary counsel take a look at the book and the stories, and he came back to me and said, no, this is all fine. He said, as long as you can't reverse engineer back to a client and identify them, it's fine to tell these kinds of stories. So when you hear these stories, just be aware that I've had it checked out and that hopefully there's no ethical breaches. So the next slide. So based on my 30 years as an estate planning attorney, there are 7 estate planning considerations. So Melissa, are you able to get up that next slide? There it is. Okay. And they include preparing for death, which is what most of us think about when we think about estate planning, creating trusts, which are an important part of estate planning, contemplating future incapacity, implementing asset protection, depending upon our profession, saving taxes, which is more of an issue for some than for others, engaging in philanthropy, which frankly, I would say the majority of my clients did in their estate planning, and then ultimately selecting fiduciaries. So those are the 7 essential estate planning considerations that I've kind of derived from my years of practice. So consideration 1, preparing for death, which is the next slide. There it is. So there's really 3 primary legal documents that we use when preparing for death in our estate planning. The first is the disposition of remains form, and I'll spend some time on that. The second is the well-known last will and testament that we all know about. And then the third is a revocable trust agreement, which probably is a good idea for most people. And we'll get into that as to why. The disposition of remains form. The next slide. So the disposition of remains form, it's surprising to me how rarely this is considered by people and by clients. It's especially important for those who are single and they may not be that close to their next of kin, or for blended families, or for conflicted families. And what happens in a disposition of remains form is you name an agent, and most states have some version of this form. You name an agent to have custody and control of your remains after you pass away. And it could be your next of kin, but it can also be someone else. And then in many states, you're allowed to give specific instructions regarding how you want your remains disposed of. Do you want to be cremated? Do you want to be buried? If so, if you want to be buried, where? So these are all important issues so that people aren't trying to guess what you may have wanted. And oftentimes when we do these forms, we'll coordinate with the funeral home, give them a copy of the form. They're always happy to have it because they frankly know they'll have business coming one day, and they're also able to try to sell advanced services, which isn't a bad thing to think about. I mean, getting your funeral arrangements done before you pass away takes that burden off of your grieving family. So just something to think about. And then, you can attach a cemetery deed to it. I mean, however that works. I mean, in my practice, I had two noteworthy cases. One was I had a brother and a sister come to me, and they were furious with their stepfather. Their stepfather had reneged on a promise to their mother. So their mother had been married to their father for 40 years or so. And then she remarried in her 70s, probably her mid 70s, to her second husband, who also had lost his wife. And he'd been married to her for his first wife for 40 years or so. And they both had agreed that when they died, they would be buried with their first spouse with whom they'd raised their families. Well, after she died, the second husband had a change of heart, and he decided that instead he wanted to have his second wife buried across the cemetery lane from where he and his first wife where his first wife was buried and where he would be buried. And that way in death, he would have both of his wives within about 50 feet. The children, the brother and sister, were absolutely furious. And there were a lot of problems with this estate. So we ended up in litigation. I had a litigator, and there were money issues involved as well. But at the end of the day, there was finally a settlement reached, and the settlement was on the earlier of 5 years or the death of the second husband, mom would be dug up and reburied with her first husband. Had mom just done a disposition of remains form and named her two children to have custody and control of her remains after she died, all of the expense and all of the aggravation from this whole situation would have been avoided. The other case was I was appointed by the court as the administrator of an intestate estate, somebody who died without a will. And our job was to see if we could locate a will, which we were not able to do, and then also to see if we could determine who his heir at law was. And so we went into his apartment, we went through all of his documents, and we found in a closet in his apartment unopened letters from someone. And when we opened those up, the person writing the letters purported to be his biological daughter. And so we did a legal search. We got, the divorce decree, and found that in fact he had had the one marriage that he'd been divorced from, that he did have a daughter, and he had never had contact with her. I guess it was just such a atrocious marriage for him that he just didn't want anything to do with anything, including his daughter. Well, went to court, determined that this person was in fact his heir at law, his biological daughter, his only child. And so she received his entire estate because he'd not done a will. And on top of that, she had the right to receive his cremated remains. And so I called her up on the phone. I said, would you like your father's remains? And she said, yes, I would. So I sent them down to her. And then I asked her what she did with her father's cremated remains. And she said she dug a hole in the backyard and she buried her father in her backyard. And so here he was buried in a state where he'd never traveled, as well as in what essentially was a stranger's backyard. And that's where he was going to spend eternity, so to speak. So he should have done a disposition of remains form if he had preferred something different. And then he could have named a work colleague or a friend or someone who could have had custody and control and could have done what he wanted with his remains. So this disposition of remains form, rarely considered, but something to really think about, especially if you're single or in a blended family or conflicted family. Okay, the second document that we think about with estate planning is the last will and testament. And of course, as lawyers, you all know that a will really only controls your probate assets. And those are assets that are in the decedent's sole name. They don't pass by beneficiary designation as life insurance or retirement accounts might. They're not held in trusts, whether revocable or irrevocable, and they're not owned jointly with right of survivorship. Even for people of modest assets or people, who have a small family, it's a good idea to do a will or at least some estate planning. I had a case of a factory worker, manufacturing worker, and he and his wife had not had any children, but throughout his lifetime, he had bought company stock and it had done very well, so that by the time he died, his estate was worth millions. And he died first and left everything to his wife because they owned everything jointly, which worked out perfectly fine. But when the wife died, she died without a will. And then the issue was, well, where does everything go? Well, we had to locate her heirs at law. And it turns out her heir at law was somebody who lived over in Eastern Europe, didn't know her, was a fifth cousin twice removed, and it was crazy. I'm in court showing ship manifests and graveyards to determine, who this person's heir at law was. And that particular individual in Eastern Europe ended up with an estate worth millions. What was sad was that the husband actually had two nieces, and those two nieces were very attentive to he and his wife. And they got nothing because the husband died first and the wife died second with everything in her name. And therefore, all of those assets went to her heir at law, who she didn't even know. And so, doing a will as just in case is very important. Just so that your property goes to those that you want it to go to and not to a laughing heir, to some stranger. The third document is a revocable trust agreement. We hear about these a lot. It acts as a will substitute, so to speak. It's a way to avoid probate. It can have the same dispositive provisions, who gets what, as a will, but it stays out of the court system. And, in some states, that's more important than in others. I mean, in some states, probate isn't that excruciating, but in some states, it can be quite an onerous process. And then in addition to avoiding probate, and as part of avoiding probate, it can expedite the estate administration. I've often found that when we don't have to go through court and have all the court deadlines and all the court notice that's required, we can get through an estate administration relatively quickly. To some extent, it reduces estate administration expenses. And one of the most important is that it maintains privacy. So if privacy is a concern for you, you should definitely have your dispositive provisions in a revocable trust. I think about you read online all these celebrity wills, and all I can think of was who was representing them as their attorney. I mean, you would think that they would have had all of their private business in a revocable trust and who was going to receive their estate rather than in a will. So, as we look at whether it be a will or a revocable trust, we often think about who are our beneficiaries. And so, Melissa, if you turn to the beneficiary, there we go. And so probably the first person that comes to mind is a spouse. And in fact, in the vast majority of my estates where it's a married couple, it's the spouse who receives the whole estate, or at least a substantial amount of it. And then, of course, next are children and descendants. And then after that, other family members, particularly if we're single or if we don't have children. We might think about siblings or nieces and nephews or maybe friends. And then ultimately charitable organizations. I find, again, the majority of my clients leave some sort of charitable bequest to their favorite charities, whether it be the law school, whether it be environmental organization, whatever it happens to be. Now, a spouse, you can't really cut your spouse out of your estate plan because they do have legal rights to inherit. Usually it's about a third, or maybe it's the income off of a third. Some states have an augmented estate approach. Other states like Connecticut, it's only what's under the will that the spouse, the disinherited spouse can make a claim on. So that all depends on state law. But typically in almost all states, a spouse has some sort of legal right to inherit. That is not true for children and descendants, except for maybe Florida and Louisiana, where a child with disabilities or a minor child has some limited inheritance rights. But otherwise, children don't have the right to necessarily inherit. I was thinking about a story or a case where I was in my office and suddenly this gentleman barges into my office and I stand up to greet him and he walks up to me and he chest bumps me. And he says, "Where's my money?" And I said, "Sorry, what are you talking about?" Well, as it turns out, his father had died and I was handling the estate. And he wanted his money because his dad had supported him throughout his entire life. But when dad died, he left his entire estate to his wife, this gentleman's mother. And I said, your mother is the beneficiary of your father's estate. She gets everything. And he was infuriated. And I said, well, you can make a claim to court, and the judge will tell you what your rights are. And another attorney can help you determine if you've got any legal rights. Of course, I knew there really wasn't anything there, but he was angry. So he did. He filed a claim against the estate. I called the court and told them about this gentleman's behavior. And I also learned from his brothers that he was a gun enthusiast. So I was a little bit concerned. So the court actually held the hearing at the police station with a police officer at the back of the room with the gun. My wife and I often joke that, trusted estate lawyers are considered to be kind of the milquetoast of the legal profession, but not always the case. We were watching a news program early when I first became an attorney, and there was a gentleman shooting someone, chasing him around a tree, shooting at him. And we learned that the person being shot at was an attorney. And my wife turned to me and she said, "Well, I'm so glad you're not a criminal lawyer," because we assumed this was an unhappy criminal defendant. Well, as it turns out, the lawyer was a trust and estate lawyer acting as trustee for a beneficiary, and that beneficiary was the one who was chasing him around the tree, shooting at him. Luckily, the lawyer survived. He was shot in the neck 7 times, but he did survive. So, trusted estate, yes, maybe we are the milquetoast of the legal profession, but it can sometimes get a little hairy, and that was one of those situations. So, as I mentioned, within a will or a revocable trust, we look at dispositive provisions. So that's the next slide. And this really has to do with the who and the what of our estate plan. Who gets what? And this can be done in a number of different ways. You can have specific bequests, which can be tangible personal property, which I've abbreviated TPP here, which are your things, your tools, your jewelry, your boats, your cars. Those can be specifically given to certain individuals. You can give cash bequests of whatever amount that you want, or you can give securities, bonds or stocks, mutual funds, ETFs. You can make specific bequests of those as long as they are controlled either by the will or by the revocable trust. The other are residuary bequests, and that's everything else. And that's really kind of basically everything. That's the bulk of our estate. I normally suggest with clients that they not make specific bequests of cash or securities of more than 1 or 2% of their estate, because you can get into a situation where you die with much less than what you think you're going to have when you pass. Or if it's been a long time from when you do your estate plan to when you die, you might die with much more. And so there's no proportionality between the specific bequests and the residuary bequests. I mean, early in my career, I remember a gentleman gave $100,000 to his church, and everything else was to be split between his 2 children. And when he did his will, he had around $1 million. So he was thinking that his church would get $100,000 and his children would split $900,000. Well, he had a lot of late in life healthcare expenses, so that when he died with $150,000. And he left $100,000 to his church, which is set, and then the balance, the residuary, to his children, which was $50,000. So they each split that $50,000, and they were quite unhappy, understandably. I didn't do that estate plan. I didn't do the will for this gentleman. They came to court, they complained, they contested, and the judge was sympathetic, but there just really wasn't much he could do to rectify the situation. So you have to be careful about specific versus residuary bequests. And I would say if you're above 1 or 2%, just say I give 1 or 2% of my residuary estate to my church and 98% to my children, or however it works. But you have to be very careful about that. Intestacy, and that's what happens if you pass away without a will or without an estate plan. At that point, your heirs at law receive, like the 5th cousin twice removed, or whatever the situation was with the factory worker that I told that story. I find it interesting. Jimi Hendrix, he died without a will, and his father, whom he despised, inherited everything. His brother, whom he loved, got nothing. And so, Jimi Hendrix, it's too bad. With all that money, he should have had legal counsel who could have advised him and helped him. When people are unhappy, as in the case of the ne'er-do-well son, or even this couple, whose father gave everything to the church, you can contest, but there's really only 3 grounds on which you can contest in most states. Formalities, those signing formalities, as well as testamentary capacity. Whenever I have a client that I'm a little questionable about their testamentary capacity, or they're doing something unusual, I'll usually send them to a forensic psychiatrist, somebody who's used to, from a legal perspective, being able to determine capacity, and have them write up a report so that we'll have that if the will is ever contested. And then the third is undue influence, where somebody is unduly influencing a person. I remember a case where a son and a mother came in to see me, and the son said, "She's leaving everything to me." And so I kind of dug down a little bit, and I said, so you don't have any other children? She says, "Oh no, I have a daughter." I said, "Okay, and you don't want your daughter to get anything?" And the mother said, No, I want my daughter to get something." And then suddenly the son said, "Mother, we've talked about this." And I was like, this is not a case that I want to take. So undue influence by a family member, by a professional advisor, by whomever, but it's a grounds for contesting a will, as well as something like mistake of fact, etc. So that's dispositive provisions, intestacy, contests. So the third document that we look at is the revocable trust agreement. Again, it can have the same dispositive provisions as a will has, but the advantage of a revocable trust agreement is that it serves some other purposes. One is it can help you when incapacity might strike. So a revocable trust agreement is sometimes confused with a living trust. They seem to be synonymous sometimes out there. But a revocable trust agreement is not a trust per se. It's an agreement under which trusts arise. And so the first trust that arises is a living trust, which is you're living, you're probably the trustee, you're the beneficiary of that of the living trust. It's your property. And the good thing is that when you or not when you pass, but if you become incapacitated, someone can step in and manage the trust property for you fairly seamlessly. So that's the living trust. And then once we cease living, we have the next trust that typically arises under a revocable trust agreement is the estate administration trust. And that's the will substitute, the probate substitute, where, you know, estate expenses, taxes, the dispositions of your estate are made in that estate administration trust. And then once that's all over and the estate administration is completed, then you might have post-administration trusts. Post-administration trusts can include trusts for your spouse, for your descendants. And the reason that you might do that might be to save taxes. That's a major reason, but it might also be to manage someone's inheritance. And it can be manage a spouse's inheritance. So maybe you have a spouse who did all the financials and the other spouse is not that financially adept. Or maybe you have a child who is young or immature, or maybe they're just not good with money. So post-administration trusts that are created in a revocable trust can be used to manage. So you've got somebody who manages the inheritance for the beneficiary. Another reason that you might do a trust for someone after you die is an ultimate disposition trust. We don't think about this much, but you know, if you leave your whole estate to someone, what happens when they die? Maybe you don't care. Maybe they can give it to whomever they like, but it's something you have to think about. I had two brothers come to see me once, and their mother had died and had unfortunately left everything that she and their father had built during their life, a very sizable estate, to her second husband. And when she and her second husband had their estate planning done, the thought was that he would die before she would. He was much older. He wasn't in the best of health. And so they just did what we in my trade call I love you wills, that is everything to my spouse. But that didn't work out because mom unexpectedly died first, and everything that she owned went to her husband. And her husband's beneficiary, after both he and his wife were gone, was his niece who lived over in Europe. And so everything that these two brothers' parents had built together, which was an estate worth millions of dollars, ended up going to this stranger living over in Europe. And it really was a shame. And in fact, this niece who lived in Europe was not a very nice person. And so when they wanted some of the tangible personal property, like, you know, family heirlooms and medals and pictures, she was very difficult. Finally, we got the court to kind of force her hand to give the non-monetary, sentimental, tangible personal property to the two brothers. But it was difficult. In fact, I think she even charged them for it. So ultimate disposition is really something to think about, you know, depending on the situation. So that's another reason to do a post-administration trust for a spouse or descendants or for nieces and nephews, for whomever. And then finally, and we'll get more into this, asset protection might be a reason to do that. So this creating trust is very important within the context of estate planning. Typically, we think about what we just looked at, revocable trusts, But you can also do irrevocable trusts. And these are done primarily for tax savings reasons. It's a way to save transfer tax and capture the transfer tax exemption, for example, of the first spouse to die. Also as a way to remove appreciation from the estate. So that's why you'd set up an irrevocable inter vivos trust. Also, you might do a special needs trust if you have a family member with disabilities, special needs. And then finally, as we're going to get into in a later consideration, an asset protection trust. So if you have a child who's a doctor or a physician or an engineer or an architect, and they have a lot of professional liability, it might make sense to set up a trust like that for them, both whether it be through your revocable trust or doing it separately as an irrevocable trust. So the third consideration, and this is really underappreciated in estate planning, is planning for the possibility, even the likelihood of future incapacity. I think around 50% of us end up in some sort of nursing care, skilled nursing or assisted living. And so we need to think about that. It might be, just the frailty that comes with age. It might be that dementia that comes on, or we have a stroke, or we have an accident. And there's 3 documents, again, that we typically think about for planning or contemplating future incapacity. The first is a power of attorney, and as attorneys, you all know what that is. It can be a durable power of attorney that is effective from the moment it's signed, or it can be a springing power of attorney that comes into effect, for example, on our incapacity. Different states, financial institutions in different states, they sometimes honor these, they sometimes don't. It gets difficult. I have always used a durable power because it's just easier to get a financial institution to honor, and you don't have to get a physician statement that this person's incapacitated, et cetera. But a power of attorney is where you name an agent to act on your behalf, in your stead, regarding financial matters, your banking, your business, et cetera. The second document is an advanced medical directive, which can include a living will. So if I'm in a persistent vegetative state or a short-term terminal condition, I don't want to be kept alive with machines. So that's a living will aspect of the advanced medical directives. You also, in your medical directives, appoint a healthcare agent, or I think some states will call it a healthcare proxy. And this is a person to make routine, emergency, end-of-life medical decisions on your behalf in case you're not able to do that. And then the third part of a medical directive in some states can be an anatomical gift, where you say, I give my body to science, or I give my organs to whoever needs them. Of course, as we get older, that's less and less of an issue. But the advanced medical directive makes clear what your wishes are, and you name an agent to follow those wishes. And then finally, the third document, but it's actually part of a document that will help you with future incapacity, is what I mentioned before, the living trust. I had delightful 100-year-old professor come to me, and she said, I think I probably need to do some estate planning. And I said, yes, indeed. I think this probably would be a good time to do that. And so we sat down, we did a will, a revocable trust, medical directives, powers of attorney. And 2 years later, she had a stroke and ended up in skilled nursing. And she had created in her revocable trust a living trust and had named one of the larger banks to act as her successor trustee. And so when she was no longer able to manage her financial affairs, within this trust, the bank stepped in and really did a remarkable job making sure her needs were met. And then after she passed away at 104, giving out her estate as she had indicated. And actually it ended up being all over the world, both individuals and organizations. So a living trust is a nice, seamless way to make sure that if you become incapacitated, your assets can be managed properly. So let's move on to consideration 4, which is asset protection. Now, most of us hear this, and of course, as attorneys, if we're in private practice, there may be some concern about that. But a lot of people hear about asset protection and they think, I don't really have any need for that. But the number of clients who come to me and they're worried about nursing home expenses is a concern that many, many people have. And only people who have millions don't really think about this too much. How are you going to pay for nursing home, especially since the cost is between $150,000 a year? And there are governmental programs out there. One is called Title 19 Medicaid. And so what I encourage anyone who has this concern to do is to go consult with an elder law attorney. They can help you understand things that you can do to expedite your qualification for governmental assistance so you're not draining your own assets. And it might be through something called a Medicaid trust. It might be by transferring real estate to children, maybe retaining a life estate when you do that. But there are ways to expedite Medicaid or Title 19 benefits. And so definitely meet with an elder law attorney if that is a concern. Other aspects of asset protection would be a special needs trust, again, for a child or a grandchild who has disabilities. What a special needs trust will do is it will prevent the state from coming back and reaching into the trust for benefits that have already been paid. And it will also keep the beneficiary qualified for governmental assistance, even though they've received this inheritance. And so special needs trusts are very important. Again, if you have a family member that you're going to leave something to with special needs, definitely see a trust and estate attorney who has a background with special needs trusts. Another aspect, the high-risk professionals we've talked about, attorneys, physicians, architects, engineers, business owners. So if that's a concern, if you have a child that might be high risk because of their profession, you should create an asset protection trust for them when you pass, or maybe even during your life. And then the third category, or the fourth category, would be beneficiaries with creditor or marital problems. The marital problem issue is really kind of a New England problem. Some of the New England states allow a divorcing spouse to reach into an inheritance or a gift that has been given. Most other states don't, but in some states it's a concern. And then if you have a child who's got a lot of creditor problems, you leave their inheritance in an asset protection trust, and it should prevent those creditors from being able to reach at least the principal, the corpus of the inheritance. So asset protection, fourth consideration, not necessarily important for all, but something to think about. Okay, consideration 5 is to do with saving taxes. And this used to be a much more widespread issue than it is now. When I first became an attorney, the transfer tax exemption, the estate and gift tax exemption, was $600,000. Well, today it's $15 million. So it's really only the ultra wealthy who have to worry about transfer taxes. And transfer taxes include estate tax, gift tax, and then GST, generation skipping transfer tax, in case you're giving to grandchildren and you're skipping the children's generation in order to avoid taxation at their level. I'm not going to spend a lot of time on this just because it impacts so few. Usually with most clients, I'll do just in case estate planning, just in case they change the law and the exemption amount is reduced dramatically, or just in case you win the lottery, or just in case you buy a stock that goes up 100-fold, whatever it happens to be. But most people, this does not impact. But if we do, we say, particularly with a married couple, you give everything to your spouse, but just in case, you give him or her the right to disclaim their inheritance, outright inheritance, into a tax sheltered trust. That's what just in case estate planning is. It's a disclaimer trust plan. Advanced planning techniques, I won't get into all of these acronyms, GRATs, ILETs, SLATs, CUPERTs. I've done all of these things for clients throughout the years. Becomes less and less of an issue now that the transfer tax exemption is so high. And then the last piece of this when it comes to taxes is it's not just transfer tax, it's also income tax, so trusts get taxed at a much higher level. Capital gains tax, if you make a transfer into an irrevocable trust, you lose the step up in basis at death. So there are considerations, and you should certainly meet with your accountant or with an estate planning attorney to talk about what the tax ramifications of estate planning might be. Okay, the sixth consideration, engaging in philanthropy. And as I said, a majority of my clients do this. Of course, they tend to be wealthier and they want to leave something for charity. There's a number of ways that we give to charity. We might give to the College of Law, might be an outright gift during life. Maybe it's the annual fund, and that's all fine. That's pretty straightforward. If you're over 70 and a half, you can make a qualified charitable distribution from your IRA. And what that does is that distribution comes out and it's not taxable. Whereas if you take a distribution from your IRA normally, you have to pay whatever your income tax rate is. And since the standard deduction is now so high, 90% of us don't use we don't itemize our deduction. So therefore we can't use the charitable deduction. So this is really helpful to have this ability to make transfers out of our IRA that aren't taxable. But we have to be over 70 and a half. And of course, once we reach 73 and we have to start taking required minimum distributions, we might just have some of that sent, for example, to the College of Law rather than taking it out of our checkbook. Because if we do take the standard deduction and we make that, it just reduces our income and it reduces our income tax exposure. So that's a great way to make an outright gift. Charitable bequests at death, again, the specific versus the residuary. Specific if it's a relatively small amount. If it's going to be 5–10% of your estate, then do that as part of a residuary bequest. And then also, if you've got a large IRA or a 401k or a 403b or whatever it happens to be, whatever the retirement account is, and you're going to leave a large bequest to charity, really ought to think about leaving the retirement account to charity because they don't pay taxes when it comes out, whereas family members will. So just something to think about. There are structured ways to give to philanthropy, charitable gift annuities. I know that Syracuse University offers this possibility, this option. You give a certain amount, you get an income stream back based upon your age and how much you gave. And then at the end, when you pass away, then whatever's left in that fund goes to the university or to whatever your charity is. You can do the same thing with charitable trust, charitable remainder trust. You can get either a specific amount through your life or a percentage, usually 5 or 6 or 7% of the trust fund every year. And when you die, whatever's left in the trust, the charitable trust, goes to charity, goes to the College of Law, or goes to your favorite charity. Private family foundations tend to be for the ultra wealthy. Usually, I used to say 2 million or more, but I think probably 5 million or more. And what happens is, let's say you leave 10 million in a family foundation, a private family foundation. Every year, if it's a $10 million principal, then say 500,000 a year, 5% would go out to the charities that you kind of indicated. And you can set this up during your lifetime, or you can also do it at death. For most of us who aren't going to leave that much to charity, another opportunity is to use a community foundation. It's the same thing. You give a certain amount of money, and they distribute out 5% is usually their spend rule per year. The community foundations tend to focus on the local community. You can also use donor advised funds with some of the financial institutions. I know Fidelity has a donor advised fund, as does Schwab. But these are just all these ways that you can engage in philanthropy as part of your estate planning. And so now we come to the last of the considerations, and that is selecting fiduciaries, which is oftentimes a conundrum for people. And I'm realizing one of those fiduciaries that really causes an issue are guardians named in the will. I guess I have it there. But the types of fiduciaries that we have in the estate planning context are executors of a will, administrators of an intestate estate, a trustee of a trust, a court-appointed conservator or guardian, and then even an agent under your power of attorney or your healthcare. Those are all different types of fiduciaries in the estate planning context. Next slide, please. The fiduciary duties, there's really three primary and then one kind of overriding principle. The overriding principle is you're trying to remain faithful to the testator, the person who made the will, or the grantor, the person who created the trust, intent. And you're trying to abide by what it was they wanted done. And so sometimes with clients, they'll do a memo for me. It's a precatory memo, not a mandatory. So it's just providing guidance. But this is how they want this trust to be administered, for example. And so we try to be faithful to the intent of the grantor or the testator. But then there are these three duties: the duty of undivided loyalty, the beneficiary's welfare is the concern of the trustee or of the executive. They can't have any self-interest in this. The second is a prudent care, that you're handling the assets properly. I had a case once where a retired lawyer was appointed by the court to handle an estate, and the estate consisted primarily of a pharmaceutical stock, and that lawyer did not liquidate and go to cash or cash-like securities. And as over the course of the estate administration, which took a couple of years, the value of that stock dropped by 75%. And I can remember going to the beneficiaries and saying, because I was representing them in this matter, do you want to sue the administrator because he didn't do his job? And they said no, they didn't want to ruin his retirement, but he could very well have been sued because he breached this duty of prudent care of, preserving the estate assets. And it would be the same thing for a trust. And then finally, the last is a duty of good faith, which is just generally, you have to act properly and prudently and in good faith. And so who do you choose as a choice for your fiduciary? So that's the last slide here. Oftentimes we think about family members, we think about a spouse or a child or other family members. Oftentimes that works perfectly fine, especially in a functional family. But if you're in a situation where there's a lot of conflict within the family, or you're single or widowed and you have children, you don't want to name one child to be the manager of the other child's inheritance. So those are things to think about. But family members are certainly
Jacob. May I speak with Holly, please?
And then
sure.
Also,
my name is Bruce Blumberg.
I've got somebody on yet. You could also name a friend or a work colleague, though you're not doing them any favors, to be honest with you. There's a lot of work involved to being a fiduciary, an executor, or a trustee. When we don't ask our friends to help us move, we're going to ask them to take on a multi-year commitment to be a fiduciary. So it's, but it's a possibility, especially if you're close to someone. Another option is a financial institution, a trust company, or a bank. I know there's a lot of complaints about financial institutions, but my experience has been they do the best they can. I think the compliance that's required of financial institutions can really create some issues. Sometimes, it makes it difficult, but at the same time, you don't have to worry about a financial institution dying or embezzling your funds. And then finally, you get to an individual professional, attorneys, accountants, financial advisors, though financial advisors usually can't act. Their firms have to give them permission. And many attorneys and accountants don't want to act in that capacity. But the downside to an attorney or an accountant is that they're going to die. So you're going to have a succession plan in place. And then the upside, though, is that they typically know the family pretty well. They know the financial situation. They understand what the client's intent was. And then finally, last, and this is coming, is fintech. I just read yesterday that Robinhood is now going to be offering trust services. And that Robinhood is this fintech program for buying and selling securities. Well, now they're going into the trust business. And so I think in time, AI and fintech will help reduce the costs for having a trust or administering an estate. So these are all the possibilities. If you're interested in taking kind of a deeper dive into estate planning, and I'm not trying to sell my book, but if you're interested, you can go to Amazon and look up my book, which is The Last Word: 7 Estate Planning Considerations, or you can go to the book's website, which is lastword.law, and it'll get you over. You can read some of the book for free on that lastword.law website if you'd like to take a look at that. But thank you for listening to this presentation. I hope that you found it helpful and instructive. And I guess at this time we're ready for questions. Melissa or Adrian?
I would say please feel free to raise your hand and ask questions. Use your microphone if you're more comfortable doing that, or to put them in the chat, whatever's easiest.
Tim, as a solo practitioner, what is your advice for the storage of original client documents, particularly when we professionals are now in our 60s and 70s? What do you do with the original wills? What do you do with the original trust documents? What's your advice?
Funny you should ask. I've been winding down my practice for the last 4 or 5 years. And I think I realized that, one of the mistakes I made was keeping original documents, because you have to get those back to the clients or to their new legal counsel, and it's quite a process. So I think what I would say is, if somebody's starting out, I wouldn't keep original documents as I did, but the firms that I had been at did, and so I just kept up that practice. I think you just have to make your best efforts. If you wind down a practice, to get in touch with people and get those documents back to them. But with respect to retaining original documents, if I had it to do over again, I wouldn't do that. In part because I've spent years getting documents back to people as I'm winding down my practice.
If I can jump in for just a minute, and I don't know if you can hear me.
Yes.
Okay. So I was a late in life lawyer as well. Was admitted around 40 years old, also from Syracuse. I recall my wills, trusts, and estates professor saying the ABA was now recommending that we no longer kept will banks. And when I was in private practice, every single will went with its with the testator, and I would have them sign a receipt, so I had proof that they did have the original, and I would scan a copy, and I had a little rubber stamp that certified it was a true and original copy of the original. But one thing I always struggled with was, oftentimes I would get husbands and wives come in to have wills together, and I always felt like there was a conflict. And I think you kind of touched on a case where one spouse was predeceased, everything went to the other spouse, they had no children. The whole notion of being able to change a will at any time, it just seems as though there's a conflict with spouses, but I never could put my finger on it. Do you have any thoughts on that?
Yeah, I mean, in my engagement letter, I always had a paragraph about, this is a joint representation. You can't tell me anything material, and I'm not going to keep it from the other client, right? And I even got to the point where in cases of divorce, initially I tried to represent both, even though they both agreed that, at that certain point in time, everything was private. But I just found it just wasn't workable. And so, when clients got divorced, I just automatically said, you need to find new counsel. And then in this case that you're talking about, yeah, I had that provision in my engagement letter, and I had it happen where someone would say, I want to revoke my power of attorney to my wife, but I don't want you to tell her. And I'd say, sorry, too late. And, that's just those are the ethical issues that come up when you're representing a married couple. But I don't know how you don't represent, married couples in an estate planning practice. So you just have to, you have to deal with it. Now, I have had cases where the husband or the wife come to me separately, and then that works fine. But yeah, there is kind of an inherent conflict, especially if they start to go in different directions. So,
If I can ask, so I'm on the website for lastword.law, and is that addressed in the book?
I don't know that it is. I don't know that I talk about the conflict between spouses. I kind of had to pick and choose what I could put in there.
Sure. Yep.
But I think it's an excellent question, and it's it's something really try to address and lay out in your engagement letter to clients, a married couple client.
Right. Okay. Thank you.
Tim, there's a question in the oh, I'll let Melissa ask it. Melissa, feel free.
Oh, I was just about to do it and saw you come off mute, so I was going to let you do it. Yes, so Mark is asking, what kind of remedies and or sanctions can surrogates court provide for abuse of a power of attorney?
So yeah, I'm admitted in New York and Connecticut, though I've never practiced before. I've never practiced before the surrogate court because my office is in Connecticut. So I've always had to go with somebody who has an office in New York. I don't know the answer to that exactly. I can speak in generalities. I've been involved in cases where, there's been when a fiduciary has acted improperly and even, embezzled, where, the court was willing to turn it over to the criminal enforcement authorities. So I think, you have that. If someone has, taken money, stolen money, it's kind of up to the judge. I had a case where actually I represented a client who embezzled a substantial amount from a trust, and his sister was quite unhappy with him because it was her children's trust. And her attorney did a really good job of coming in and looking up applicable statutes, and we're looking for triple damages and all sorts of things. And this is in Connecticut. And so, yeah, I think, again, short of turning it over to a criminal authority, a criminal enforcement authority, I'm not sure what the probate court can do. But I can't speak for the surrogates court in New York. They may have more power than a Connecticut probate court had.
Thank you. I know that we're at 1, which was sort of our advertised cutoff time, but there is at least one more question in the chat, and there may be others that people want to ask. So if people have to log off, we'll still record. We'll read this question, and Tim, if you're able to stay on for a couple more minutes to field it. So Connie is asking, would you discuss funding a revocable trust?
Yeah, so, I'm always surprised, many estate planning lawyers will draft these revocable trust agreements and then they just lay there. And so I always included actually as part of my fee that I would help people fund the trust. So whether it be, deeding a house into the revocable trust, or whether it be moving brokerage accounts in, those are all the things that should be done. Otherwise, what's the point of doing a revocable trust and having that living trust created under the revocable trust agreement? So, yeah, I think for practitioners, it's responsible to help people, but you have to bill for it. But it's responsible to help people either get brokerage accounts or maybe large bank accounts or real estate, real property into the trust before they die. Because then one of the main reasons for the trust, which is to avoid probate and to expedite the estate administration, it can't be done because you'd still have to go through probate, and then it would be the will that would typically then pour over into the revocable trust after death. But it's kind of like what's the point? So I think it's important to assist clients with funding the revocable trust. Any other questions?
Hey,
All right,
I'm not seeing any other
good,
questions in the
right on time.
chat. Perfect. Perfect. Well, would you like me to close, Tim? Thank everyone for joining, or would you like to do that?
No, you go ahead, Melissa. You're fine.
Oh, perfect. Well, thanks so much to everyone who gave up an hour of their time today. This was so interesting and so helpful and just really practical and relatable tips. And I have read Tim's book, so he put it last, didn't mention it, didn't give you, didn't have a full slide to promote it, but I will promote it. It's if there is such a thing as an entertaining read about what to do when facing the end of life, this book would be it. And so I will recommend it. And we're happy to connect you with Tim or with any of us here at the Office of Development at Syracuse University College of Law. So thanks again to everyone tuning in. This session has been recorded, and once the recording is up, we will send everyone the link as follow-up.